Code of Civil Jurisdiction should follow. It deals with the means and instruments by which justice can be done in the courts. The ultimate aim, therefore, of the code is to do justice fairly and expeditiously. The procedural law is not meant for delaying the justice and is framed to provide the courts with a uniform and unquestionable procedure so as to avoid diversity in the manner of dealing with cases before the courts. If no code was enacted, it would be quite likely that the procedure followed by courts would have been in a chaotic condition. The procedure has impression of long and calculated experience, so it seeks to provide well-defined ways for dispensing justice. By the code, hardships are reduced to the minimum. In short, the code aims to remove the impediments that check the free and uninterrupted flow of the fountain of justice. The preamble of the code indicates that it consolidates and amends the law relating to procedure of the Court of Civil Jurisdiction. So the court, being a consolidating act, repeals only those statutes which are repealed by it expressly. All others should be deemed to continue in force without any modification. The code does not affect any special or local law or any special jurisdiction or power conferred or any special form of procedure prescribed by or under any other law for the time being in force. The code is general law, so in case of conflict between the code and the special law would prevail over the provision of this code. Whereas the special law is silent, where the special law is silent on a particular matter, the code Cpc applies, but it must be applied consistently with the special enactments. The Indian Succession Act 1925, the Indian Divorce Act 1869, and the Provincial Insolvency Act, etc., are special enactments and they lay down their special procedure. The Code of Civil Procedure extends to whole of India, and there is no limitation in the Code of Civil Procedure or in any other act in force in this country, except excluding foreigners from the jurisdiction of Indian courts. The code is exhaustive in regard to matters specifically dealt with by it, and in respect of those matters of law be sought for within it. But however exhaustive it might be, it cannot provide for matters and all circumstances that may come up before a court of law in a fast changing society, and in those respects the court is left free to act according to equity, justice, and good consciousness, the principle of which are prescribed under section 151. As Peacock CJ said, since laws are general rules, they cannot regulate for all time to come, so as to make express provision against all the cases they may possibly happen. Section 151 specifically provides that nothing in this code shall be deemed to limit or otherwise affect the inherent power of court to make such orders as may be necessary for the ends of justice or to prevent abuse of process of the court. The code is not exhaustive of all forms of procedure that may be called for in the administration of justice. To make it more useful and up to date, the Code of 1908 was heavily amended in 1976. However, this also failed to reduce the load of pending cases in the civil courts of the country. The number of such cases is about 2.03 crore. Their parliament passed a bill in 1999, but it could not become law owing to the opposition of lawyers. A fresh attempt was made by Parliament 2000, keeping in view the grievances raised again in 1999 bill. After being passed by Parliament, it received the assent of the President. It was notified that it had to come into force with effect from 1 July 2002, which is entitled as Civil Code of Procedure Amendment Act 2002, Act number 22 of 2002. The beginning of the British rule in India marked the establishment of a uniform system of administration of justice. In the beginning, there were no codified laws. In order to meet the difficulties that arose during this period, certain orders were passed by the then high officials which directed the subordinate court to adopt certain procedure in certain sets of cases, but they were too limited and too insufficient to fulfill the need of the time, owing to the ever-growing litigation as well as to the fact that new and unprovided for questions arose during the pendency of suit. The need for a codified law of procedure was keenly felt, and in order to meet this requirement, the first Civil Procedure Code was passed in 1859, being the Act 8 of 1859. There is no doubt was a uniform civil code. It did not extend to the Supreme Court in presidency towns and to presidency small cause courts. Before this, the procedure of the Mofusul courts were to be regulated by special act and regulation which came to be repealed by Act 10 of 1861. In 1861, the Court of Sadar Diwani Adalat and Supreme Court were abolished by High Court Act of 1861. It was the first attempt at codification and hence it remained defective and crude. This first act of 1859 was changed in 1877 and again in 1882 another civil procedure code was passed. In 1900, the present Code of Civil Procedure was passed and all the several amendments including Amendment Act of 1976 and 2002 has been made in the main act. Its arrangement and system has been retained. Arrangement of the Code. The arrangement of the Code of Civil Procedure is that it is divided into three main divisions. The first deals with sections, the second with orders and the rules, and the third with schedules other than that which contains order and rules. The sections are binding on all civil courts in India and may be changed only by legislation. While orders and rules may under certain circumstances section 121 and 122 be altered or amended by different high courts for guidance of their own court or court subordinate to them. These rules, if and when changed, should not be in a way of at variance with the section until so changed. These rules have the same force of law as section themselves. State the main change brought about by the Code of Civil Procedure Amendment Act 2002 into the Code of 1900. What is their chief object? In fact, the changes brought about by the Code of Civil Procedure Amendment Act 2002 only reflect the mitigation of rigors with which a similar bill was passed by Parliament in 1999, which had introduced quite harsh provision with a view to reduce undue delay in disposal of civil cases, but unfortunately it could not become the law due to strong protest from the lawyers. As a result, for a while it appeared that the matter had been thrown into a dustbin. However, very shortly an amended bill was presented afresh in Parliament in 2000, keeping in view the recommendation of Bar, political parties, Law Commission and the Permanent Committee in Parliament. This bill, after being passed by Parliament, got the assent of President on 23rd May 2002, became the Act and after notification came into force with effect from 1 July 2002. The main changes introduced by Code of Civil Procedure Amendment Act 2002 may be summed up under the following heads. Transfer of decree. The court passing a decree shall not be entitled to execute it against any person or property outside the local limits of its jurisdiction. New subsection 4 inserted in section 39 of the Code of 1908. Private transfer of property after attachment not to be void in certain cases. Section 64 entitled as private alienation of property after attachment to be void has been retained as subsection 1 and new subsection 2 has been inserted. This new provision annex the provision of section 64 shall not apply to any such private transfer or delivery of the property attached or of any interest therein made in pursuance of any contract for such transfer of delivery entered into and registered before the attachment. No second appeal in certain cases. Section 102 provides that no second appeal shall lie from any decree if the subject matter of the original jurisdiction suit is recovery of money and it shall not exceed rupees 25,000. It does not exceed rupees 25,000. No further appeal in certain cases. No further appeal can now be made in cases where an original or appellate decree or order is heard by a single judge of a high court and the judgment and decree has been passed by such single judge. New section 100A. No further appeal can now be made in cases where an original or appellate decree or order is heard by a single judge of a high court and the judgment and the decree has been passed by such single judge. Section 100A. Service of summons through fax message, etc. The summon may now be served on the concerned parties through the message or electronic mail service or courier service. New Order versus Rule 9. Summon may now be served on the concerned parties through the message or electronic mail service or courier services. Plaintiff himself allowed to serve the summon. On the application of the plaintiff, the court may permit him to serve the summon personally. New Order 5 Rule 9A. Allowing amendment of pleadings no longer to be a general rule. Under the Code of 1900, grant of amendment has become the rule, and its refusal only an exception. But now the provision inserted by the Act of 2002 in Order 6 Rule 17 has made the grant of amendment somewhat difficult. It lays down that no application for amendment shall be allowed after a trial has started unless the court comes to the conclusion that in spite of due diligence the party could not have raised the matter before the commencement of trial. On the application of the plaintiff, court may permit him to serve the summon personally. Plaintiff himself allowed to serve the summon. On the application of the plaintiff, court may permit him to serve the summon personally. New Order 5 Rule 9A. Change in procedure on admitting plaint. For this purpose, old Rule 9 of Order 7 has been reframed as under, where the court orders that the summon be served on the defendant. It will direct the plaintiff to present as many copies of the plaint as plain paper as there are defendants within 7 days from the date of such order, along with requisite fees for service of summon on the defendant. It has also been made clear that if the plaintiff fails to comply with the provision of Rule 9 mentioned above, it shall be an additional ground for rejection of the plaint under Order 7 Rule 11, Sub Rule 1 of Rule 11 of Order 7. Change in procedure on admitting plaint. For this purpose, old Rule 9 of Order 7 has been reframed as under, where the court orders that the summon be served on the defendant. It will direct the plaintiff to present as many copies of the plaint as plain paper as there are defendants within 7 days from the date of such order, along with requisite fees for service of summon on the defendant. It has also been made clear that if the plaintiff fails to comply with the provision of Rule 9 mentioned above, it shall be an additional ground for rejection of the plaint under Order 7 Rule 11, Sub Rule 1 of Rule 11 of Order 7. Time limit for filing written statement. Under 1908 Code, the defendant could file his written statement at the first hearing or before the first hearing, or within the time allowed by the court. Under 1908 Code, the defendant could file his written statement at the first hearing or before the first hearing, or within the time allowed by the court. But now, by virtue of the 2002 amendment, the defendant must file the same within 30 days. Within 30 days from the date of, from which date? Can you tell me? From which date? The date of service of summon on him. However, in exception circumstances, the court may extend the said time limit, but such extension too cannot be more than 90 days. Time limit for argument. Court may fix time limit for oral argument by either of the parties in a case. The submission of written argument depend upon the discretion of the court. Orders 8, Rule 3A and 3D. Adjournment for the purpose of filing written argument will also depend upon the discretion of the court. EBIT 3C. Recording of evidence. In every case, the examination in chief of a witness shall be on affidavit, and copies of such affidavit shall be supplied to the opposite party by the party who calls him for evidence. It has also it has also been specified that where documents are filed and the parties rely upon their truth, the proof admissibility of such documents which are filed along with affidavits shall be subject to orders of the court. Order 18. New Rule 4 Sub Rule 1. Role of Commissioners. The High Court or the District Judge, as the case may be, shall prepare a parcel of Commissioner to record the evidence. Order 18. Rule 4 Clause 6. If any objection is raised during the recording of evidence before the Commissioner, then it shall be recorded by him, and such objection shall be decided by the court at the stage of argument. Order 18. Rule 4 Proviso. The Commissioner shall submit his report to the court within 60 days of his appointment, unless this period of time is extended by the court for reasons to be recorded in writing. Order 18. Rule 4 Clause 5. Time limit for pronouncing judgment. Court has to pronounce the judgment within 30 days. 60 days in exceptional and extraordinary circumstances from the date on which the hearing of the case was concluded. Prospective efficacy of the changes. While it is too early to say as to how far the changes made by the 2002 Act would go in reducing the delay in dispensation of justice, as at present they are just in their infancy, but one can fairly hope that they would certainly gear up the speed of trial. However, a disappointing note about these changes is that they have not touched any significant aspect of execution of degree. It may be pointed out the rules relating to execution of the decree are given in order 21 of the code and are 106 in number. Most of these rules are frivolous, time consuming, and cumbersome. Owing to these outdated rules, even a successful litigant remains deprived of reaping the fruits of justice for a period unlimited. Therefore, it can hardly be expected that there shall be any reduction in time consumed by execution proceeding. Another aspect of matter may also be noted, that is delay in pronouncing the judgment by the High Court, by reserving the judgment after the argument are concluded. In this connected quite recently, the Supreme Court in Anil Rai versus Bihar, AIR 2001, Supreme Court 3173, has observed that whereas justice delayed in justice denied, justice withheld is even worse than that. It may be pointed out neither the Constitution nor any legislation provide any time limit for high courts to pronounce their judgment. To meet this problem, the court has issued detailed guidelines which have to be followed till the absence of any legislation in this regard. Coming back to 2002 changes, it may be concluded that they do avoid certain inconsistency prevailing in the administration of civil justice, but they do not guarantee immediate justice to poor litigants. So that's all about CPC. If you find it useful, like, subscribe.